We are now ready to talk about testamentary capacity and intent. So remember the basic requirements before a person can make a valid will. Okay? At least 18 years of age. Hindi pwedeng may kulang kahit na ilang araw lang. The testator must have already celebrated his 18th birthday or the 18th anniversary of his birth. If a will is made by a testator, let's say 2 days before his 18th birthday or a week before his 18th birthday, that's not a valid will. Okay? Kailangan nakapag-celebrate na ng 18th birthday. Nakapag-dibu na. Alright. And of course, must be of sound mind. Okay? Soundness of mind. Okay. You better remember the Codal definition of soundness of mind under Article 799, okay, especially paragraph 2. To be of sound mind, all that the law requires is that the testator, at the time he makes his will, okay, should know the nature of the estate to be disposed of. He should know the proper objects of his bounty, and he should know the character of the testamentary act. As long as the testator knows all of these three, at least in a general way, then he has testamentary capacity. Okay. The law is even more categorical. If you look at paragraph 1, okay, it is not required that the mind of the testator be wholly uninjured or unimpaired by disease or any other cause. In other words, kahit na may konting topak, pwede pa rin. Can still make a valid will. As long as he satisfies the minimum requirements under paragraph 2 of Article 799. Okay. He must know the nature of the estate to be disposed of. This simply means that the testator must know in a general way at least what are his properties. Okay? He may remember that he has, a house and lot somewhere in Quezon City. Even if he cannot remember the exact address, that will be sufficient. He remembers that he has a substantial deposit with a certain bank. He may not remember the exact amount, but as long as he knows it's quite substantial, it's in the millions, that should be considered sufficient. He knows he owns valuable paintings, okay, by both local and foreign masters. Meron siyang Van Gogh, merong Rembrandt, may Amorsolo, okay. He may not remember the exact details about each and every painting, but as long as he knows in a general way that he has these paintings, he has soundness of mind. Okay. Of course, the presumption is always of soundness of mind. And that's the reason why I always tell my students we are all very lucky and fortunate because we can always invoke that presumption in our favor. We are all presumed to be of sound mind. Okay? Of course, that's a disputable, rebuttable presumption. So, even if your seatmate is acting a little bit out of the ordinary, medyo ibang kilos. Remember that there is always that presumption of soundness of mind. Okay? Of course, under the Civil Code, sometimes the presumption is reversed. Okay? And when would this be? If the testator 1 month or less, hindi 1 month or more, 1 month or less, before the making of the will was publicly known to be insane, then the presumption is that he was not of sound mind, and he who alleges otherwise would have the burden of proof. Okay. Along the same line, if the testator made his will after he has already been placed under guardianship, precisely because of unsoundness of mind, then the presumption is that he did not have soundness of mind at the time of execution. All right. Testator must know the proper objects of his bounty. That's one of the requirements under paragraph 2 of Article 799. This simply means that at the time of the execution of the will, the testator should still know who are the persons closest to him, who are his close relatives, who are the individuals who, by nature of their close relationship to the testator, would have the natural right to expect something from him. Who are the people who in the ordinary course of events would be given properties by him? This would be his closest relatives. If at the time that the testator makes his will, he could not even recognize his own wife. He does not even recognize his own children. Okay? Which can sometimes happen. Then he would no longer be capacitated to make a valid will. He must know the character of the testamentary act. This simply means that he must know that he is making a last will and testament. That it is this document, this will, which will be used as basis for distributing his estate when he dies. He should know that it is within his power as testator to revoke his will anytime before his death. Okay? Supposing that a person believes in the existence of unseen beings. He's somebody who believes in dwarves, okay, elves. Niniwala siya na may mga duwende. And let's even say he even claims to talk to these creatures. Is he necessarily incapacitated to make a will? I do not think so. Okay? As I always say, I believe in the existence of angels. I believe that each one of us has a guardian angel. I believe in that. Okay? If for no other reason than that, otherwise, I could not explain how I was able to get home driving my car during those days when I would still get involved in heavy drinking sprees. Okay? I always like to believe that at those moments in my life, my guardian angel actually took over the wheels, the steering wheel. Okay? That does not mean I'm incapacitated. So mere belief in the existence of these unseen spiritual beings will not necessarily render a person incapacitated to make a will. There is no maximum age for making a will. There is a minimum but not a maximum. Just like in marriage, di ba? You have a minimum, 18. There is no maximum age. So, in the same way, even if the testator is already 110 years old, okay, sabi nga amoy lupa na, he can still make a valid will. He may be suffering from a host of diseases. Lahat ng klaseng sakit nasa kanya. May pneumonia, may diabetes, may heart condition, may hypertension. Okay? Name it, he has it. That does not incapacitate him to make a valid last will and testament. As long as he is still able to meet the basic requirements under paragraph 2 of Article 799. As long as he knows, in a general way, the nature of the estate to be disposed of, the proper objects of his bounty, and the character of the testamentary act. How about drug addicts? Can they make valid wills? Yes. As long as at the time of execution of the will, okay, they still knew the nature of the estate to be disposed of, proper objects of their bounty, the character of the testamentary act. The same thing may be said with respect to alcoholics. Okay? People who cannot last through a day without imbibing alcoholic drinks. Okay? They can make a valid will as long as they satisfy the basic requirements under Article 799. The capacity to make a will must be possessed at the time of execution. As long as the testator was capacitated at the time of execution to make a valid will, his will is valid, even if he subsequently becomes incapacitated. If Mr. X made a will at the age of 22, and when he made his will, he was of sound mind, but 2 years after the execution of the will, he became insane. And he died in a state of insanity. His will should be allowed. What matters is that when he made the will, he was fully capacitated to make one. Conversely, if at the time of execution, the testator did not have capacity, even if he subsequently acquires capacity, his will remains invalid. If the will was made by a testator at the age of 17 and he died 10 years later at the age of 27, his will is invalid because when he made that will, he did not possess the required capacity. Okay. Let us now go into one of the most fertile grounds for bar examination questions. I refer to the forms of wills. Okay? Madalas nagtatanong dito sa forms of wills. I would therefore strongly advise you to go over these provisions, starting with Article 804 up to Article 814.